Senator Sass urged us to do our job. I agree. Part of our job is to review the record of the nominee as thoroughly and deliberately as possible, looking to all the relevant and probative evidence. We can't do that on this record. Mr. Chairman, you have said multiple times that your staff has already reviewed the 42,000 pages of documents produced to this committee at 5:41 p.m. yesterday. Both sides are using the same computer platform to review the documents from Mr. Burke. The documents had to be loaded into this platform overnight and couldn't be concluded until 6:45 a.m. this morning. How is it possible that your staff concluded its review last night before the documents were even uploaded? That's this platform that both sides are using here. Simply not possible, Mr. Chairman, that any senator has seen these new materials, much less all of the other relevant documents that have been screened by Bill Burke, who is not the National Archivist. And this situation, when we say it's unprecedented, is truly without parallel in our history. And I'm going to quote from the National Archivist. It's, quote, something that has never happened before. And the archivist continued, this effort by former President Bush does not represent the National Archives or the George W. Bush Presidential Library, end quote. So, Mr. Chairman, I renew my motion to adjourn so that we have time to conclude our review of these documents, and so that also my request under the Freedom of Information Act, which is now pending, to the National Archivist, to the Department of Justice, to other relevant agencies, can be considered and judged. That Freedom of Information Act will require some time, I assume, to conclude. I renew my motion, Mr. Chairman, and ask for a vote on the motion to adjourn. As I said earlier, Rule 4 provides, quote, the committee chairman shall, not may, shall entertain a non-debatable motion to bring a matter before the committee to a vote. That seems pretty clear to me, Mr. Chairman. I've made a motion to bring before the committee a motion to adjourn under the rules. With all due respect, you are required to entertain my motion. And I would just add this final point. All of these documents will come out. They will come out eventually, as soon as 2019 and 2020. By law, these documents belong to the American people. They don't belong to President Bush or President Trump. They belong to the American people. It's only a matter of time, my Republican colleagues, before you will have to answer for what's in these documents. We don't know what's in them, but the question is, what are they concealing that you will have to answer to history for? Mr. Chairman, I renew my motion to adjourn.
You quote the rules very accurately, but those rules apply to executive business session. We're not in an executive business session, so I deny your
Mr. Chairman, with all due respect, I ask you to point to me the language in Rule 4 or anywhere else in our rules that limits its scope to executive business meetings. There is no such language, Mr. Chairman.
I would have you quote language to the contrary.
Could you quote me that language?
No, I'm asking you. You quote me a language to the contrary of what I ruled.
There is no language to the contrary. I'm asking for a vote in this session now. There's nothing that precludes the vote in our hearing at this exact time.
Okay, I've ruled. You want to proceed, do you?
Well, if the chair, with all due respect, is ruling against me. I move to appeal the ruling of the chair. With all due respect, the chairman is not above the rules of the committee. I ask for a roll call vote to overturn the ruling of the chair and to allow for a vote on my motion to adjourn these proceedings.
That would be an appropriate motion if we were in executive business session, but we're not in executive business session, so it's denied.
Mr. Chairman, I will proceed under protest. We've had a lot of rhetoric so far about rules and norms. I am very regretful that the chair has adopted this stance, which in my view contradicts our basic norms and rules. But I will proceed. Mr. Chairman, I have fears about what this nominee will do with respect to our rule of law, but also about basic rights that have been established by past Supreme Court precedent. And the only way to test what his fidelity to the rule of law is, in fact, is to ask, as I have asked every judicial nominee coming before me when I have served on this committee in hearings, whether he believes past decisions of the Supreme Court were correctly decided. So I'm going to be asking you, Judge Kavanaugh, whether you believe Roe v. Wade was correctly decided.
Mr. Chairman.
I'm going to be asking you.
Mr. Chairman, may I ask a question? I was under the impression each of us had 10 minutes for an opening statement. We'll have 50 minutes for questions. But
Let me clarify.
and then plus I would ask, Mr. Chairman, the various members have been making speeches all day long and have not been confined to their 10-minute opening statement.
Yeah. Okay. Well, like I told you,
I think I have time left on my 10 minutes.
you will have time. I'm going to let you finish. Just a minute. I was hoping that the 10-minute rule would stand, but we got off to a very bad start. And we got off to a bad start, and everybody started exceeding their time limit. So I guess as long as we have to stay here and get this all done today. If we have to stay into the night, we're going to stay, but I'm not going to cut anybody off now that I didn't do it right away. And like you said, mob rule, I've always said to myself when advising other people, either you run the committee or the committee runs you. And I let the committee run me this time. So let's just proceed as we have and let Senator Blumenthal take what time he wants. I hope you won't go too long.
I'll be very judicious.
Thank you.
Mr. Chairman. Thank you.
I don't know what that means.
Yeah, I don't know. Not answering.
I'm sorry, Senator Corner, and I can't agree with you. We just proceed. Senator Blumenthal.
Thank you, Mr. Chairman.
Next time, Mr. Chairman.
So I will be asking Judge Kavanaugh whether you believe Roe v. Wade was correctly decided, whether you believe Brown versus Board of Education was correctly decided. Judicial nominees have figured out all kinds of ways to avoid answering that question. First, they said they felt it would violate the canons of ethics. There are no canons of ethics that preclude a response. Then they said that they felt a decision might come before them, an issue in a case that might arise. And more recently, they've adopted the mantra that they think all Supreme Court decisions are correctly decided. But you're in a different position. You've been nominated to the highest court in the land, and your decisions as a potential swing vote could overturn even well-settled precedent. And there are indications in your writings, your opinions, as well as the articles you've written and some of the memos that have come to light, that you believe, for example, Roe v. Wade could be overturned. And that's why I want to know from you whether you think it was correctly decided in the first place, and other decisions that are regarded as well settled or long established. In fact, I have these fears because Judge Kavanaugh, this system and process has changed so radically. In fact, you have spent decades showing us in many ways what you believe. Or to put it more precisely, you've spent decades showing those groups like the Federalist Society and the Heritage Foundation and others what you believe. They're the ones who have really nominated you because the president outsourced this decision to them. In those opinions and writings and statements and interviews, you've done everything in your power to show those far-right groups that you will be a loyal soldier on the court. And I'm going to use some of those writings and some of the timing and other indications to show that you are more than a nominee, in fact, a candidate in a campaign that you have conducted. That seems to be, unfortunately, the way the system has worked in your case. The norms have been dumbed down and the system has been degraded, but I think that we have an obligation to do our job and elicit from you where you will go as a justice on the United States Supreme Court based on what you've written and said, and also what you will tell the American people in these hearings. I join in the request that's been made of you, that you show the initiative and ask for a postponement on these hearings. I think that this process has been a grave disservice to you, as well as this committee and the American people. If you are confirmed after this truncated and concealed process, there will always be a taint. There will always be an asterisk after your name. Appointed by a president, named as an unindicted co-conspirator, after the vast majority of documents relating to the most instructive period of his life were concealed. The question will always be, why was all that material concealed? You've coached and you've mentored judges in going through this process. You are as sophisticated and knowledgeable as anyone who will ever come before us as a judicial nominee. So you know that we have an obligation to inquire as to everything that can be relevant. And it's not the numbers of documents. It's the percentage. There were no emails when Justice Ginsburg was the nominee. The documents that we've been provided contain duplicates. They're full of junk. We need everything that is relevant, including the 3 years that you served in the Bush White House as staff secretary, the most instructive period of your professional career. So let me just conclude by saying, what we share, I think, is a deep respect and reverence for the United States Supreme Court. I was a law clerk, as you were. I've argued cases before the court. Most of my life has been spent in the courtroom as U.S. Attorney or as Attorney General. The power of the Supreme Court depends not on armies or police force, it has none, but on its credibility, the trust and confidence of the American people. I ask you to help us uphold that trust by asking this committee to suspend this hearing and come back when we have a full picture with the full sunlight that our chairman is so fond of espousing, so that we can fully and fairly evaluate your nomination. Thank you, Mr. Chairman.
Once again, I would remind